I am calling the Hillsborough County Land Use Appeals Board meeting to order. Today is Thursday, April 6th. It is 1:30 p.m. I'd like to introduce Tom Hisney from Development Services, Sonia Rodriguez, Manager of Citizens Board Support, Cameron Clark, Assistant County Attorney. I am Ricky Bauman, Chair of the Board. To my right, to my far right, is Board Member Justin Evans. To his left is Board Member Peter Schwartz. To my immediate left is Stanley Hinn. And to his left is new Board Member Haley Kennedy. Our recording secretary is Allison Desiano. These are the rules for today's proceeding. This board is an appellate body and shall only consider the land use hearing officer's decision and the record. This hearing shall be limited to the record on appeal as defined in the LDC and consist only of limited oral argument based upon said record. No additional evidence may be submitted or considered by board members. The order of presentation will be staff's introduction, petitioner's case, opposition's case, rebuttal by petitioner. Only the following have standing to appeal or to intervene in appeal, which is filed or may be heard at this hearing: the applicant, the administrator, any person or entity which appeared before the land use hearing officer and presented testimony or other evidence, or presented evidence themselves or by proxy to the LUHO, and was adversely affected by the decision of the LUHO. The board reserves the right to limit presentation to 10 minutes per side. This time limit may be extended for good cause. Pursuant to this reservation, the presentation is hereby limited to 10 minutes for each side, with rebuttal limited to 5 minutes. The basis for a good cause extension: the case reasonably requires additional time. Proposed additional presentation is relevant. Proposed additional presentation is non-cumulative, the amount of time used to answer the board's questions. The board shall have the authority to uphold the land use hearing officer's decision or to remand the case back to the land use hearing officer. If the board remands a case back to the land use hearing officer, the board shall specify the reason for the remand and specify the issues for the land use hearing officer to address. I believe our next order of business, Ms. Rodriguez, is to give the oath of office to our new member, Haley Kennedy, Esquire.
Ms. Kennedy,
Allison?
if you can please.
Ms.
Kennedy, if you can please stand and raise your right hand.
We're going to try to raise the volume because we can hardly hear you, Allison.
Okay. Can you hear me now?
Yes.
Okay, Ms. Kennedy, if you can please turn on your microphone as well, please. I, please state your name,
I, Shannon Haley Kennedy,
do solemnly swear
do solemnly swear
that I will support, protect, and defend
that I will support, protect, and defend
the Constitution and government of the United States
the Constitution and government of the United States
and of the state of Florida,
and of the state of Florida,
and that I am duly qualified to hold office
and that I am duly qualified to hold office
under the Constitution of the state,
under the Constitution of the state,
and that I will well and faithfully perform the duties
that I will well and faithfully perform the duties
of the Land Use Appeal Board, which I am now about to enter.
of the Land Use Appeals Board, which I am about to enter.
Yes, ma'am. Thank you. And congratulations.
Thank you.
Ms. Rodriguez, would you please administer the oath to the witnesses for today's cases?
Okay. Those of you giving testimony must take the oath of witness. Please stand and raise your right hand. Do you swear or affirm that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth? I do. Thank you. You may be seated.
Ms. Rodriguez, would you please call the case?
Board members, I'm sorry. I
Mr.
actually
Clark.
don't, I'm sorry. I was gonna say, I don't have a mic, but that's okay. I actually prefer to sit over here so I can see you guys if you ask me any questions. Just to let you know, your first application today, Ms. Rodriguez can advise is actually out of order because there was no notice proof provided to staff. However, a representative of that applicant is here, and I believe is going to ask for continuance anyway. So if it's out of order, it would have automatically continued to May. I believe it's going to be request continuance to June, possibly. I can, from working with staff, verify as far as the zoning interpretation application that they're going through, sort of parallel to this process, is ongoing. So I believe Jessica Eiserman from Stearns Weaver can speak to that.
Did you want me to call the case?
Yes, let's call the case because
call the case.
we can
Okay.
grant the continuance. It's,
Okay. The case is appeal number APP 221514, petition file number variance 221060. The appellant and the owner is Tony Sullivan. The representatives are Jacob Kramer and Simone Silvino from Stearns, Weaver, and Miller. This is to appeal the decision of the land use hearing officer who denied the request for a variance for 632-foot reduction to the required separation from an existing community residential home type A. The location is 401 Mahogany Drive in Sefner. The folio is 066-883-2256. The size of the property is 0.21 acres, more or less. The existing zone is RSC6, future land use RES6, service area urban, and the date of the land use hearing officer hearing was August 22nd, 2022.
Good morning, Jessica Eiserman. I'm an attorney with Stearns Weaver Miller. I am stepping in for Simone Savino today. She is out on maternity leave. We have a land use appeal or a LUHO appeal for a variance before you. However, we would like a continuance to June. We have met with Mr. Hisney and other county staff and have submitted a zoning interpretation application. We submitted that on Tuesday. Staff has 30 business days to make that decision. That decision potentially renders the variance unnecessary, and therefore this appeal would be dismissed. However, if that zoning interpretation does not go in the direction we expect or think it should go, then we may pursue appeal methods through the zoning interpretation process. All that to say is we're requesting a 2-month continuance to June to give staff time to evaluate and submit their opinion on that application, and then for us to evaluate our appeal options at that point.
Thank you, Ms. Eiserman. Board, I would like to make a motion that due to both councils requesting a continuance, I think that would be reasonable and fair, and I would like to make a motion that we approve the continuance. Is there a second?
I'll second that.
Please state your name and
Dallas
motion.
Evans, I will second that as well.
Okay. Is there any discussion on the motion? If not, then I will call the members. Ms. Kennedy?
I'm in agreement.
Okay. Mr. Hind? Excuse me.
I agree.
Mr. Schwartz?
Aye.
Mr. Evans?
Aye.
And I, Ricky Bauman, Chair, also aye.
Thank you.
Continuance is granted.
Hopefully not see you in June.
That hearing will be June 9th, 2023, and it is on a Friday.
Thank you. Appreciate it.
Mr. Rodriguez, could you please call the next case?
The next case is on page 3 of your agenda. It's item 1B. The appeal number is APP 230067. The petition file number is variance 221373. The appellant and the owner is Alex Omar Wright. And this is to appeal the decision of the land use hearing officer who denied the request for a variance for a 2-foot increase to the maximum permitted fence height to allow a 6-foot high fence with the required front yard on the subject property's east side along Jackson Springs Road. The location is 8615 Jackson Springs Road in Tampa. The folio is 007-008.0000. The size of the property is .33 acres more or less. The existing zone is RSC 6, future land use RES 4, service area is urban, and the date of the land use hearing officer hearing was November 21st, 2022. Sir, state your name and address for the record, please.
My name is Alex Wright. My address is 8615 Jackson Springs Road, Tampa, Florida, 33615.
Please proceed, Mr. Wright.
Like she said, I am appealing the decision of the officer just due to the fact that I was not aware initially that there was any kind of restrictions. Initially, there was a 4-foot fence. When I bought the property, the fence was dilapidated. I got materials to replace the fence myself due to the fact that, it would bring up the curb value of the home. The other reasons for me putting in that fence is the proximity to the Jackson Springs Recreational Center. There's not necessarily bad things happening there, but there's been times where things have been left in front of my home, whether it be razor scooters or things of that nature, where things have ended up in my property, as well as just due to the fact that it was more for security. I have a son and I have a young daughter as well. And why I mentioned security is that an issue in the area, around that area in Hillsborough, is an issue with homeless. There's been homeless people that have literally been sleeping on a mattress right up the street from my house. That went on for about 2 to 3 months before somebody finally got them out of there. So there's little things like that I've been dealing with. So the reason mainly that I'm asking for this variance is security and safety of my property.
Thank you, Mr. Wright. Is that your full statement?
Yes, ma'am.
Does any board member have any questions of Mr. Wright?
My name is Stanley Hind. Question for you. I believe, if I'm not mistaken, I saw in the packet that the neighbors adjacent to you, the height of their fence, you installed to match that height. Was that correct?
Yes, there's an existing wall there. And that wall is actually right up to where my fence is. And in fact, if you really want to look at it, technically that wall is a few inches further than my fence. But it's literally the same height as that wall. I assume that wall was up to code or whatever that may be. That wall is actually a big nuisance in a sense for me when I come to exit the property. So that's the reason why I put up the type of fence that I have. Initially, when leaving the property, if I was to exit to my left, I would literally almost need to be in the street to kind of get a clear view while exiting. So the type of fence that I installed was definitely to help with visibility, while at the same time, it doesn't necessarily impede the view of the home or anything like that.
Now, the fence, the wall that you're referring to, does that run along the property line separating you two, or does that run along the street side of it?
It runs along the wall separating both of us.
Okay.
Yeah.
And the photos that you've submitted of other fences, are those all, they are in proximity of your home?
Yes. In fact, there's a few houses around my house that have the same type of fence.
6 foot height?
Yes. There's one home in particular that is butted up to Jackson Springs. So, they have to deal with the Jackson Springs Park in their backyard in a sense, but they're fenced off. There's a gully of sorts that kind of blocks off the park from them. But they also do have a fence around the front, which is why I kind of assumed that, it wouldn't have been a problem. There are other people that I know who also live less than a mile, 2-mile radius from me that have fences of that nature. They mentioned the fact that that they end up getting variances. So I wasn't even aware of it initially. I was just, like I said, I'm a first time homeowner. So this is all new to me.
Okay.
So I just was trying to up the curb appeal on a home that definitely needs it.
All right. Thank you.
Does any other board member have any questions of Mr. Wright? Mr. Wright, I have two of them. I understand that you purchased the property in 2022. During your due diligence period, did you notice any debris or trespassing with the dilapidated fence?
No, I kind of fell in love with the property and didn't really do any of that initially. So like I even mentioned with the homeless guy that was sleeping less than a mile from my house, that was almost around Jackson Springs and Sheldon, right in that area there. That I think kind of happened when they kind of basically fenced off an area that was a homeless encampment. There's a few of them that were around the area where the homeless kind of made into encampments. And they ended up cutting a lot of the trees on Webb Road and on Hillsborough and Webb, close to this dermatologist's office. They cut a lot of the trees that were there, which basically displaced a lot of people that were camping in those areas. That is kind of when I saw that pop up. My neighbor to the right of me, they did their best to kind of get the person out of them themselves. We later had a conversation about this, and they even had issues with that. But as far as anything like that, no. I knew that there was a park across from the street, yes. So I assumed that there was going to be, foot traffic. That's not a problem because I have a little girl who I expected to take advantage of that. But I literally found the house in about 30 days and was able to close on it, luckily, in less than 60. So at that point, I got a great rate on it and things like that. So I didn't necessarily check on all the other things that I should have. Yes.
Question, please. I don't have a good view I haven't seen in the packet a good view of your property, say from the front. So the 6-foot walls are to the sides of your home?
No, it's in the front. The walls, yes. So there is
So they're going back?
Yes, there's a 6-foot wall going back. And if you were to be looking at my house, that would be a 6-foot wall, brick wall on the left, cinder block wall, going all the way back to the actual water.
Okay.
So, and on my right, which I'm going to be replacing that fence now because it's a fence that's falling apart as well, and Ian did a lot of damage to it, is a 230-foot run to the water as well. So that's my next project, is to have that replaced with a chain link fence.
So that's a wood picket? Or
Yes.
something like that?
Currently, exactly.
Okay. Yeah, because I wanted to make sure that I understood it, that you were talking about the fence to the front of the street.
Yes.
Okay. How about your next door neighbor on either side? What height is their front?
So the neighbor to my left, they have, their driveway is a circular driveway.
Okay.
So they have their fence, they have their little circular driveway, and then they have the fence about the same height, but they have it at the house.
It's set back?
Yes, exactly.
Okay, so we're not
Exactly.
dealing with the front setback or
Yeah.
anything like that? Okay.
Yeah.
And the other side, please?
The other side, that's my neighbor Mike Machado. Their fence is more set back because of the fact that they have a drain field right in the front.
Okay.
Yeah,
Okay. Thank you, Mr. Wright.
thank you.
Any other board member have any questions of Mr. Wright? Ms. Rodriguez, are there any other witnesses here for this case?
No, but I believe the county attorney is wanting to speak on something.
Thank you. Okay. Thank you, Mr. Wright.
Thank you.
Mr. Clark?
I'm sorry, board members, I just need to clarify something about the record. On pages toward the end of the packet, is there a number on those pages? I just want to clarify that, and Sonia, these don't have the appeal page numbers that you guys normally use, which means it was probably not part of your packet.
Probably not.
So I have a concern that.
Yeah, because my packet is numbered.
It would appear that in filing his appeal, the appellant added to the record. It appears there's photographs of surrounding properties that are part of the record of appeal that were not before the hearing officer. And the concern I have is that this board acts as an appellate body. It's almost like when the hearing officer gets a record, creates a record through the hearing itself, gets documentation, the record of this case is sort of frozen in time at that moment. And what you review is that frozen in time record. It cannot be supplemented later with additional materials. And I'm given to understand from staff that the appellant here submitted additional photographs with their application, and staff unfortunately included those in the appeals packet. Staff should not have done that. The appeal document should just be they're filling out the appeal form. Any additional materials provided with it, we already have the record. I mean, the record of the hearing is already preserved by the county, so there should be no supplemental materials that are included in the appeals packet. And the standard of review for this board, just to remind you, we also have a new member, is it's not rehearing the case de novo or from scratch. It's a matter of, based on the record that was before the hearing officer, was the hearing officer's decision based on substantial evidence. This is a denial of a variance application, which would mean the hearing officer found that the appellant did not submit competent substantial evidence to satisfy at least one of the 6 variance criteria that are found in Chapter 11, Section 110402B of the Land Development Code. And therefore, it's a denial. In order for a variance to be granted, the hearing officer has to find in the affirmative on all 6 variance criteria. So your task here today is to look at the record. If this board determines that in fact there is substantial evidence to support each of the 6 criteria, the board can remand it to the hearing officer, or if you find that there was not, then you can affirm the hearing officer's decision. I'm only concerned because, and I don't know if this is something that we could do on the fly, but I would want to instruct the board to disregard certain pages if those pages were entered into the record after the hearing, because that essentially that jeopardizes the legality of the decision of this board if this board is weighing evidence that the hearing officer did not have. So with begging the board's pardon, could we have just a moment to see if we can determine the origin of those pictures so we can try to at least instruct you to disregard certain pages of the record?
Yes, Mr. Clark, I think that's very reasonable. We'll take a 10-minute recess. Thank you.
Thank you.
That's when I do it, yeah.
Take that record that the board had and Blue had, you create.
Yes.
So come over to Tom.
I have to go by one, by one, by one, by one. We have numbers. I don't recall seeing those pictures. See, because it would be. Gotta be a fast way. Go see what that number is on his page. It's on that with the pictures on it. I don't recall seeing those pictures.
Madam Chair,
6, 7.
I think we can reconvene at your convenience. I can clean this up.
Okay, Mr. Clark, please proceed.
Okay, so in examining this, it appears that the additional photographs that were submitted by the appellant were not included in your record packet. So there is nothing to exclude. Everything is properly before you. And so you can go ahead and hear this case. Everything's okay to hear it. Thank you. Sorry for the delay.
Not a problem, Mr. Clark, thank you.
No, wait. Come over here. What about that picture?
Will any board member
Yeah, I
present
see.
make a motion on this
This-
case, whether to approve
Is that-
the decision of the land use hearing officer or a motion to remand the case to the land use hearing officer?
I'd like to make a motion.
Name?
Stanley Hind, to remand it back to the land use hearing officer.
Is there a second to the motion?
Second. Clara Lawhead. Clara Lawhead. Clara Lawhead, I second.
Madam Chair, I'm sorry to interrupt again. Sonia, can you read the page numbers into the record? After it's 1B5, I think was the start.
1B5, 1B6, 1B7, 1B8, 1B9, 1B10.
Okay. Those contain photographs that apparently with his appeal, the appellant submitted additional materials. So in rendering your decision, please disregard the photographs. You're only allowed to consider what was before the hearing officer at the time of the hearing. Thank you.
Thank you, Mr. Clark. Before we have any discussion, as per our county attorney, please disregard those photographs that were not submitted to the land use hearing officer but were added to the record in error after the fact. Is there any discussion on this motion to remand? Then I will ask the question, on what basis are we remanding it to the LUHO? We have to have a basis to remand it. And if we feel that the LUHO came to an improper decision by not applying the criteria correctly, we have to have a basis for it. No discussion. Mr. Clark?
Mr. Chair, you may wish to begin by going over the 6 criteria to determine which ones the hearing officer, so in many instances, the hearing officer will find some were met, but some are not. But yes, if there is a remand, it can't just be, empathy for the appellant. It has to be based on some specific criteria of one or several of the 6 variance criteria that you think the appellant did satisfy, but that the hearing officer thought they did not.
Thank you, Mr. Clark. Ms. Rodriguez, my Wi-Fi is not working. Could you please read the 6 criteria from the LUHO?
Okay. And the decision?
Yes.
Okay. Number 1, are the alleged hardships or practical difficulties unique and singular to the subject property and not those suffered in common with other properties similarly located? No, the subject property is similarly shaped and situated as others properties similarly located along Jackson Springs Road and in proximity to Jackson Springs Community Center and Skate Park. The applicant could install a fence of up to 4 feet in height in the subject property's front yard as other properties similar have done. The record evidence does not support any findings of hardships or practical difficulties unique and singular to the subject property and not suffered in any common or other properties similarly located.
Thank you, Ms. Rodriguez. That's number one. Is there anything in number one that we are remanding it to the Lujo for? This is discussion now on this motion to remand. Hearing none, Ms. Rodriguez, please read number two.
Number two, would the literal requirements of the LDC deprive the property owner of the rights commonly enjoyed by other properties in the same district and area under the terms of the LDC? No. The subject property is similarly shaped and situated as other properties similarly located along Jackson Springs Road and in proximity to Jackson Springs Community Center and Skate Park. The literal requirements of the LDC would allow the applicant to install a fence of up to 4 feet in height in the subject property's front yard, as other properties similar have done. The record evidence does not support a finding that the literal requirements of the LDC would deprive the property owner of the rights commonly enjoyed by other properties in the same district and area.
Does there any board member find any criteria under number two for the motion to remand? Hearing none, Ms. Rodriguez, please read number three.
Number three, would the variance, if allowed, substantially interfere with or injure the rights of others whose property would be affected by the allowance of the variance? No, there is no evidence that the variance is, if allowed, would substantially interfere with or injure the rights of others whose property would be affected.
Thank you, Ms. Rodriguez. Does any board member find any reason to remand under criteria three? Ms. Rodriguez, number four, please.
Number four, is the variance in harmony with and does the variance serve the general intent and purpose of the LDC and comprehensive plan? No. No, the subject property is similarly shaped and situated as other properties similar, located along Jackson Springs Road and in proximity to Jackson Springs Community Center and Skate Park. The applicant could install a fence of up to 4 feet in height in the subject property's front yard, as other properties similar located have done. There is no record of evidence to support any finding that a variance is in harmony with or serves the general intent and purpose of the LDC and comprehensive plan to foster and preserve public health, safety, comfort, and welfare, and to aid in the harmonious, orderly, and progressive development of the unincorporated areas of Hillsborough County.
Does any board member find any criteria under number four to remand it to the land use hearing officer?
I would,
Name.
Stanley Hind, based on invariance with the harmony, that would be my substantiation to send it back, just for further review by the board to look into other properties as well to see if it fits the neighborhood.
Thank you. Ms. Rodriguez, number five, please.
Does the situation sought to be relieved by the variance result from an illegal act or result from actions by the applicant or property owner resulting in a self-imposed hardship? Yes, the record shows that when the applicant required the subject property, there was a 3-foot wood fence within the required front yard along the subject property's east boundary. The applicant removed the 3-foot high wood fence and installed a 6-foot high aluminum fence without inquiring about the LDC fence height requirements. The applicant now seeks a variance to the fence height to accommodate the 6-foot high fence he installed. The record shows the situation sought to be relieved by the variance resulted from the applicant's own actions.
Is there any board member find any criteria under number five to refer to the Lujo?
I do, Stanley Hind. If the applicant was following perhaps set standards that have already been set forth and approved by other homes, it may not have been felt as though it was an illegal act. And under that criteria, I would like to send it back for review.
Is there any other comment on number five? Mr. Rodriguez, number six, please.
Will allowing the variance result in substantial justice being done, considering both the public benefits intended to be secured by the LDC and the individual hardship that will be suffered by a failure to grant the variance? No. The subject property is similarly shaped and situated as other properties similarly located on Jackson Springs Road and in proximity to Jackson Springs Community Center and Skate Park. The applicant could install a fence of up to 4 feet in height in the subject property's front yard, as other properties similar located have done. The record shows that when the applicant acquired the subject property, there was a 3-foot-high wood fence within the required front yard along the subject property's east boundary. The applicant removed the 3-foot-high wood fence and installed a 6-foot-high aluminum fence without inquiring about the LDC fence height requirements. The applicant now seeks a variance to the fence height to accommodate the 6-foot-high fence he installed. The evidence does not support a finding that allowing the variance will result in substantial justice being done.
And does any board member have any discussion on the criteria under number 6? Thank you, Ms. Rodriguez. We have a motion on the floor to remand, a motion and second to remand this case to the land use hearing officer under criteria 4 and 5. We can discuss it. Is it 4, is it 5, or is it both?
I would like to agree with both.
Well, would you like to amend your motion to include both?
I
4
would
or
like to
5?
amend my motion to include both.
Is there a second?
Shannon Kennedy, I second.
Any discussion on the motion to remand it back under criterias 4 and 5? There being none, I will call for a vote.
Madam Chair, before you vote, I just want to clear up one thing. So looking at the record of the hearing officer's decision, the hearing officer would appear to have ruled in the appellant's favor on only one of the 6 criteria, which is criteria 3. It's a little bit weirdly worded from the way it reads in the Land Development Code, but the Land Development Code says in order to prove a variance, the hearing officer must find, and part 3 is, that the variance, if allowed, would not substantially interfere with or injure the rights of others whose property would be affected by allowance of the variance. The hearing officer wrote, would the variance, if allowed, substantially interfere with or injure the rights of others, blah, blah, blah. The answer is no, it would not. So she rules in favor of the appellant on criteria 3. Of the other 6 criteria, it would appear that she rules against him on the remaining 5. Okay, so you are making a motion to remand it to take additional evidence on criteria 4 and 5. But the concern that I have is she also ruled against affirmative finding on provisions 1, 2, and 6. And what that would mean is when it goes back to the hearing officer and she takes additional evidence on 4 and 5, even if she finds additional evidence, it's still a denial because she has ruled in particular that, the very first variance criteria, the alleged hardships or practicable is unique and singular to the subject property and not suffered by those who in common with real property similarly located. And the finding was no, that the property is similarly shaped and situated. And in proximity, it basically shares the same hardships as some of the neighboring properties. So you can, the remand vote you're considering at this time creates a dilemma because it goes back to it's sent it back to the LUHO, but the necessary result is whatever the LUHO determines on those 2 criteria, it would still be a denial.
Even if they're affirmative, it would still be 3-3.
Because it would be, 3 would be found affirmative and 3 negative, and then it just puts us back here potentially regarding the other 3. So I think my suggestion would be if the board does not believe that there is competent substantial evidence to support all 6 of these criteria that the board can itemize, then it's probably worthwhile to affirm because all 6 have to be satisfied in order the variance be granted. Okay. And I'm happy to take any questions if you have them.
Does any board member have any questions of Mr. Clark?
I have a question for you. If I were to amend my motion to include all of them, except for item number 3, which has already been approved, that she was in agreement with, on the basis of taking into consideration all the neighboring properties that have or may not have similarly height of fences installed, based on the conditions, can we do that just as a blanket remand?
Sure. I'm not going to constrain any motion that you want to make if you want to make one on the all 5 negative criteria. I think that that's just fine. I just wanted to advise you that in the end with a remand, if you're not going to address all the criteria that were found to be negative, ultimately it can't change the result.
And based on that, I would like to revise my motion to include all item 1, 2, 4, 5, and 6 to go back to the land use hearing officer on the basis of considering and reviewing adjacent properties within proximity of their installed fences for consideration.
Is there a second to the motion to amend?
Shannon Kennedy, second. I second the motion.
Is there any discussion on the amended motion to consider the 5 criteria that were negatively found by the Lujo?
Shannon Kennedy has a question. If there was an original permit applied for prior to the code enforcement, I guess that would be for you too, would the variance process have been the same?
Yeah, building permits are not required for fences.
Okay.
Is there any other discussion on the motion?
I have a question. This is Clara Lawhead. The question goes back to number 1. The other similar shaped and situated properties. What I understand, Mr. Carter, is the pictures were of other properties should not be considered because they came in after the application was completed.
Yes, the pages that Ms. Rodriguez referenced by number would appear to have been submitted with the appeals application. And the appeals application should just be the application itself. It should not contain any other materials that weren't already heard by the hearing officer. Now, that said, I understand what the motion of the board is. What ultimately would happen if the board ultimately decides to remand this? At that time, Mr. Wright or anyone else could actually supplement the record with additional evidence. So the photographs in question could become part of the record, but they aren't for purpose of today's hearing.
So that's Clara Lawhead again. That's not actually starting over, but it allows additional documentation to be submitted at the next, at the remanded hearing.
It's not starting over in the sense that the record that you guys have now will still be the record, but you can add on to it. It's not like what you have now gets recycled and it starts over. It's you have what you have and then you can add pages to it if there's another hearing.
Thank you.
Are there any other comments or discussion on this motion? Hearing none. Ms. Kennedy?
Aye.
Mr. Hind?
Aye.
Ms. Lawhead?
Aye.
Mr. Schwartz? No. Mr. Evans?
Nay.
And I also no. That is 3-3.
So board members, I would advise on a 3-3 your motion to deny. I would request someone to make a motion for approval, knowing full well that may also fail 3-3. If that happens, then we would have to continue this application to a subsequent hearing date in order to allow for the presence of an odd number of board members.
So, Mr. Clark, if I have it right, you're asking to approve the motion to remand?
No, so you have a failed motion to remand.
Correct.
So there are only 2 options before this board the first time that appeal comes up. The board can either uphold the decision of the hearing officer or remand.
Right.
So a vote to remand has just failed 3-3. The only other option for the board would be to uphold. I would suggest if anyone who wishes to uphold the decision, make that motion, see if there's a second, take a vote on it. Ultimately, if that failed, the only outcome left would be to continue this case to a future date in hope of getting an odd number of board members. For what it's worth, this is not without precedent. We actually had this happen.
We've had this, yes.
We had this happen.
This is
in all the years
yes.
I've done this, we had never had it happen until just a few years ago. And then I want to say it almost happened in consecutive hearings. We kept getting tie votes.
Yep.
So
it did.
But because all your options have not been exhausted yet, before continuing, I would suggest if anyone wishes to uphold it, to perhaps make and second that motion and see what happens. If you cannot get to a 4th vote on that, then I would suggest that the board remand it to a later date.
Thank you, Mr. Clark. I, Ricky Bauman, Chair, make a motion to uphold the decision of the Land Use Hearing Officer. Is there a second?
Dallas Evans, I'll second.
Is there any discussion on the motion? And I will call the roll. Ms. Kennedy,
Nay.
Mr. Hind,
No.
Ms. Lawhead,
Yes.
Mr. Schwartz,
Nay.
Mr. Evans,
Aye.
and I, 3-3.
Okay, so board members, I would suggest at this time a motion for continuance. As far as the date, I think Ms. Rodriguez could help. You could continue it to May, but I believe you have no other hearings for May, and you know now that you have one for June because of the
Yes.
earlier continuance. So it's at your discretion. You can choose a date you continue it to, and Ms. Rodriguez will try to secure an odd number of board members.
Thank you, Mr. Clark. I would like to make a motion that we continue this case to our June meeting. Is there a second?
Dallas Evans, I'll second that.
Is there any discussion on the motion? Okay. Ms. Kennedy,
Aye.
Mr. Hine,
Aye.
Ms. Lawhead,
Aye.
Mr. Schwartz,
Aye. Sorry.
Mr. Evans,
Aye.
and I. Motion carries. This case will be continued to our June meeting.
That would be June 9th, 2023, and it's on a Friday.
As we've concluded the cases, Ms. Rodriguez, we have the approval of the minutes of December 9, 2022. These have been sent out. Is there a motion? Is there any discussion on the minutes from December 9 of 2022? Any errors or omissions that have been found? If so, I will make a motion to approve the minutes of December 9, 2022. Is there a second?
Dallas Evans, I'll second.
Is there any discussion? Ms. Kennedy,
Aye.
Mr. Hine,
Aye.
Ms. Lawhead,
Aye.
Mr. Schwartz,
Aye.
Mr. Evans,
Aye.
and I, Ricky Bauman, Chair. Aye. That motion is carried to approve the minutes. Ms. Rodriguez, is there any further business?
Not that I can think of. I think we're good.
This board is adjourned at 2:17 p.m. Thank you all for coming.